So thank you everybody for attending. My name is Addie Chung. I'm the Associate Director of International Student Career Engagement at the USC Career Center. And I'm really excited to introduce Rich Yam from WR Immigration. We've been partnering with WR since this fall to offer workshops on immigration, student visas, green cards for students and employers. And Rich is doing this workshop on self-sponsored green card options. So I hope that you're going to learn a lot from him. I'm sure that I will. So I will let Rich introduce himself as well.
Thanks, Eddie. And yeah, welcome to today's presentation. My name is Rich Yam. I'm an immigration attorney with probably about 15 years of experience in helping individuals with their immigration journey in the United States. I'm delighted to be here today to share my knowledge with you on a topic that I think is very important, particularly for students and, particularly, it's important. It's one of those areas that can be important a lot of the time for immigrants, but particularly now, if we are entering a recession, maybe employers are less likely to want to sponsor. So it's always good to keep this option of being self-sponsored open and available to you so that you can kind of give that a shot and basically, take some kind of control over your own future in terms of where you're going to go, post OPT, post student studies, all of this kind of stuff. So yeah, today I'm going to be walking you through the process of obtaining a self-sponsored green card. We're going to cover various self-sponsored green card options, including the national interest, main focus on national interest waiver and EB1, which is for the extraordinary ability one, in addition to some kind of coverage of the family-based green card options and some of the other stuff like that. So I think I'm just going to dive right in and just get started on this.
One little thing before you start, I just want
Sure.
to know if you have any questions over the course of Rich's presentation, please type them in the Q&A. And we will get to them we will have a dedicated Q&A time at the end of his presentation. So we'll go through those.
Perfect. Thank you. Okay, so let me see if this is going to work. Yes. First off, because I'm a lawyer, we have to always start these things with a legal disclaimer. This does not constitute legal advice. This is an informational webinar. It's to give you some overall idea, give you an overview, a flavor of the topic so that you can have an idea of what options exist for you. If you're looking for specific advice about your own complex situation, then we always recommend you actually schedule a consultation with an attorney, talk to someone who can kind of look at the specifics of your case, because this can vary massively. It's just one of those areas where you don't want to rely too much on this informational thing, because we're going to go through it, but we're going to cover a lot in about an hour. And obviously there's a lot more to it in practice, so just keep that in mind. That being said, I've mentioned my name's Rich Yam. My email address I'm going to put up here right now. If you do have specific questions, you do want to reach out, if something's not clear later on, or you have to drop off at some point, just keep that in mind. You can always reach out to me. I'm happy to help as much as I can. You might detect a bit of an accent. I'm originally from the UK. I mentioned I've been out here about 15 years, practicing exclusively immigration law during that time. And I've gone through a similar process, kind of gone through my personal history. I went through a J1 visa, H1B, green card, that side of things. I'm not extraordinary. I'm not in the national interest. So I didn't go through one of these particular things, but I've helped a lot of immigrants go through this particular route to getting a green card. But yeah, I don't want to focus too much on me. I'm going to move straight on to the topic so we can get through things. But I did want to just mention that we do have an interesting YouTube series called Chatting with Charlie. Charlie Oppenheim is the former Department of State chief. He's now working with us as our Director of Visa Consulting. particularly if you're Indian or Chinese national and you're looking for more information about visa bulletins, which we'll touch on a little bit later. I think it's worth just checking in on that, just to get updates on where things are at and how they anticipate those changes to come in the future. So moving on. First off, I want to kind of go through the fact that this is, the permanent residence overview is really there's two main parts. Now, most of today, we're really going to be focusing on the immigrant visa portion. Now, the immigrant visa forms the basis for immigration to the United States. It doesn't necessarily give you a green card. It doesn't even give you work authorization in and of itself, but it does give you the ability to then file the green card and kind of move forward from there. So forming the basis of immigration, this is what we're going to talk about in terms of national interest waiver. All of these are examples of immigrant visa, which you get. Then you would move on to the second stage, which is either the adjustment of status or AOS, which is typically done here in the US to adjust you from non-immigrant status to immigrant status, which would be to kind of move you onto a green card. So that's the adjustment portion. The consular processing would be if we were processing you abroad. The immigrant, kind of going through a consulate there. This is often done if you do not have a situation where you're here in status, if you're abroad or something like that. But that's the actual immigration portion. And it's a lot more straightforward than the first section most of the time. If you don't have criminal issues, previous immigration issues, that kind of stuff, it tends to be a lot more straightforward. But it is something just to kind of keep in mind that is something you need to get onto down the line. That second stage of the green card process, I mentioned here quota backlogs. Those occur prior to that second stage. So you have to be able to be current in that visa bulletin that we were talking about in order to move forward with that second stage. So this first stage, what basis for immigration do you have? How do you get that immigrant visa? Now, technically, as much as, this presentation is going to be about self-sponsoring, but technically the national interest waiver and the alien of extraordinary ability, EB-11 or EB-1A, they are classified as employment-based. But the idea here is that you should be able to file for this immigrant visa on your own. So you don't need an employer to actually sponsor the petition for you. Family-based, again, you would need someone to sponsor you for that, but it is something that you can kind of do without needing to involve an employer. Green card lottery is something that you can just go ahead and file directly or apply for. We'll get onto that in a bit. So the general green card process. I mentioned that, step one, you're looking at this immigrant visa petition, and I-140 is the employment base. So this would be typically EB-1, national interest waiver, something like that. I-130 is more family-based sponsorship. So you file the immigrant visa petition, you get that approved. Second step is to actually file the I-485 or the application to adjust status here in the US. The good thing about being able to do that here in the US is that then gives you certain benefits. You get often an employment authorization document or advanced parole travel document, which can then allow you to travel, can then allow you to work while the overall green card is still pending. Now, the I-140 and the I-485 can, in certain circumstances, be concurrently filed together. This is particularly true of EB-1, also sometimes NIW if you're born, typically if you're not born in China or India. Because of visa backlogs, those cases you often have to wait before you can file stage 2. But for an EB-1, for national interest waiver, in certain situations, you'll be able to file both cases at exactly the same time. Whether you do that or not is kind of up to you. Generally speaking, it can be better to file the I-140 first, because then at least you know, hey, you've been approved, and you can move forward with stage 2. If you file both and stage 1, this national interest waiver thing gets denied, then you're basically out of luck. The adjustment, the second stage gets denied as well. Did want to mention premium processing. Premium processing does allow you to expedite your adjudication on these cases. EB1 can be expedited for 15 calendar days. So you pay an extra $2,500 to the government. You get a decision in 15 calendar days on that. It can be a decision or it can be a request for evidence. We will get onto a request for evidence later. The idea being that you either get an approval, you get a request for evidence. If you get a request for evidence, they typically give you 3 months to respond. Oftentimes it'll be a case of, well, we think you meet this criteria. We're not sure about these, provide more evidence, this kind of stuff. So you give them more evidence, or at least you get the opportunity to do that. And then once you respond, they have 15 calendar days to make a final decision. Now, the premium processing has actually recently been extended to national interest waiver. For some reason, it's not 15 days for national interest waiver, it's 45 days. But, you know, I'm not going to look a gift horse in the mouth. This is great. For a long time, national interest waiver didn't have premium processing. We were looking at, you know, sometimes 10, 11, 12 months to get a decision or request for evidence on those. So, you know, it's not 15 days, but 45 days is still pretty good on those. You don't have to premium process, but regular processing doesn't really have any guaranteed timeframes. It can be 12, 14 months or more. So that can go up depending on how many people are applying at any particular time. I mentioned the I-485, which is that second stage of the green card or the adjustment of status portion. That can't be premium processed. Background checks involved, all of this kind of stuff. I wish there was some kind of premium processing, even if it was a 45 days or something like that, but it just doesn't exist. You're looking at regular processing, probably 8 to 10 months. They will sometimes call you in for an interview. Doesn't always happen, but you know, recently we've actually seen them kind of go steer more away from interviews into a point where they might actually just issue the green card and you suddenly receive the green card in the mail. But there is a chance of interview. And like I put here, processing times do change. You never really know how long it's going to take. Things can just start taking longer. So let's get on to EB2, National Interest Waiver. Now, the preliminary test here is that the position requires, or that you have an advanced degree or exceptional ability, which can be, you know, diploma, 10 years of experience. Typically, advanced degree could be either a master's or bachelor's +5, or be able to show, like I said here, that you have exceptional ability, which is tough, but it's a case of showing that you're somewhat above those who are normally working in that field. Now, the key part of this that I want to focus in on is going to be this 3-pronged test, the Danassar case. In order to show that you qualify for a national interest waiver, you're going to have to prove to immigration, and this is where, you know, all of this is kind of subjective, but there are things that you can use, and we're going to go into this in a lot more detail. But you're going to have to prove to immigration that your proposed endeavor has substantial merit and national importance, that you, the beneficiary, are well positioned to advance the proposed endeavor, and that on balance, it would be beneficial to waive the job offer requirement and labor certification, which we'll get into in a little bit more detail in a little minute. But let's start with substantial merit and national importance. I would say just a quick heads up on national interest waiver. I mean, we predominantly do these cases for researchers, scientists, this kind of thing, but it's not exclusive to that realm. You know, you can actually, and there have been cases increasingly where entrepreneurs have been eligible for a national interest waiver, have been able to make that case and get approvals, this kind of stuff. So, you know, I'm going to kind of focus more on the science and research type side of things. but it can apply to other fields as well. So yeah, substantial merit and national importance. The idea here is really that there's some kind of national flavor to what it is that you're doing. Obviously, most scientific research is considered to have some kind of substantial merit, national importance, but being able to show something like the federal government, some kind of national international organization is funding this type of research, generally kind of helps to prove this, prove that there is some kind of merit and national importance to what it is that you're doing. The second prong is that you're well positioned to advance the endeavor. This is about you. What are you specifically doing? And what is your position within that field? In order to prove this, you're looking at things like evidence that the research is widely used or relied upon. Idea being that this research isn't just helping your employer, it's impacting the field as a whole. Showing that you have special skills, you have experience or an advanced degree that kind of helps with this side of things. The idea here is really showing that your position is going to suit one of these situations where you are going to be able to advance this endeavor. You actually are able to move this kind of field forward. And the last part of this is evidence that you will continue in your field. This is, even though I've mentioned this is a self-sponsored category, so you don't need an employer to petition for you, to sign the forms, to do all of that side of things. So we often get the question, well, why do I need to show that I'm going to continue in my field, and what am I going to do on that front? I mean, this is where, having some kind of a plan that you will continue research is going to be useful. This could be showing a job offer, showing that you do have employment opportunities, you have job offers, so that you can show, even though you don't technically need an employer to file for this, you can explain that you will continue in this field. It won't be a case of it's approved, you go off and do something else. If you can show that you have these kind of positions lined up, some way to continue your research, this is always good. And I put on here that, postdoc or graduate students, what's the situation there? I mean, the problem is because these positions are temporary, you're going to want to be able to show that you have something lined up for once the PhD process is completed. So again, if you have job offers, anything like that, that can be useful. And the third part of this is that on balance, is it beneficial for immigration to waive the job offer and labor certification requirement? To really kind of understand this, you have to understand that the most standard employment-based sponsorship requires a labor certification. So the employer would have to go out into the labor market, place ads, show that there's no minimally qualified workers, that the US workers that are available, so to really show that you're not taking jobs away from Americans. Now, the key part here is that, we need to protect American workers. That makes sense. That you want to make sure that you sort that side of things out. But the idea here is that the national interest is such that it kind of offsets that. So it should mean that you can still give someone a national interest waiver without having to go through this labor certification requirement for this individual, because we're looking at other factors that are in the national interest. So this is a balancing test where we're weighing that national interest of the research against the national interest of enforcing the labor certification process. So the key thing here is really, it makes logical sense. If you're looking for a scientist or a researcher to do work, you don't want the minimally qualified person to be doing that job. You want the best person for that job, because it's a job that's going to be in the national interest of the United States. So this is where, this is part of the overall argument that you put into immigration to show that based on your position, what you're doing, all of this kind of stuff, it makes sense and it's okay for immigration to waive that requirement and allow you to get a green card without having to go through this super burdensome process of the employer placing ads, recruiting, months and months of extra work through Department of Labor. So that's the idea that we have there. So what do you have to show? Well, national interest waiver is a much lower standard than EB1, which we'll get onto later, which is the extraordinary ability green card. But similar type of evidence is going to be required. Unlike the EB1, you don't have to show you've risen to the absolute top, the absolute pinnacle of the field. But as we've kind of discussed, you have to still establish that you have impacted the field and you will continue to impact your field. But what evidence can we use? Well, there's a few different areas that we're going to cover today in terms of what you want to be able to have, what you want to be able to provide. The first one I want to go into is really publications. Now, publications are important. We really want, as much of this as possible, really. But what is important? Well, the distinguished nature of the journal is hugely important. We're looking at impact factor. We're looking at the ranking by impact to be able to show that your the journal that you've published in has an impact on the field, all of this side of things. If you've got publications where you're first author, that's a very strong factor. The lower your name appears in a list of co-authors, it can make it more difficult because it's like, are we attributing this impact on the field to you or to, these other hundreds of people that could be co-authors? I mean, this is something, we see a lot, particularly in atmospheric science, in space science. There's sometimes hundreds of people in a collaboration, and it's so much better if you stand out. Doesn't disqualify you if you're just a co-author, but again, mentions this is a balancing act. We're looking at everything you've got, and if you are a first author, if there aren't many other co-authors, it just kind of increases the strength of that particular evidence when we provide it. Citation record, this is something that is very important with immigration. We put here as number one most important factor current in adjudications. I think this is one of those things that immigration likes. We provide them with a bunch of documentation, but immigration likes to be able to do somewhat of their own research because they feel like that everything we give them sometimes is a bit obviously biased because you're providing it, and they can go on Google Scholar and they can see what's listed on there. And that is something of kind of independent evidence that they can look up to see if this person qualifies. So I would definitely recommend that if you're looking to go down national interest waiver route, make sure that your Google Scholar page is updated and you keep it updated. The immigration officers often will look at how many citations, this side of things. I don't like to say how many citations particularly is enough, just because it, like I mentioned, it very much depends. It can be a balancing test. But I think a rule of thumb that I would tend to follow is we'd be looking at maybe 50 citations for a strong national interest waiver. More would be required for the EB1, which we'll get onto later. But around about 50 would probably be a good kind of standard amount to qualify for a national interest waiver. What other evidence can we use? Well, if you serve as a reviewer for journals, that can definitely work. Particularly if it's some kind of national committee, international organization, organizing conferences, all of this can be useful. I would mention that it really has to be in your own name. If you're doing review work for your principal investigator, probably not going to work. If you're ghosting them, something like that, it's unlikely to be as useful, because we don't have your name on it. Immigration often comes back, we'll get onto this later, but on awards that your company has won, if your name isn't listed on it, they're going to be like, well, show that this is actually an award for you. Press releases, these kind of things can be really good. Any other media coverage, again, just to show the impact on the field, because typically there isn't press unless it's something that's going to have or is having an impact. Grants can be important, especially, again, if you're listed, even if you're postdoc, PhD, all of this side of things. Obviously, if you're a principal investigator, that can be better, because it shows you've got this higher role, this side of things, but all something just to keep in mind. Awards, poster recognition can be very cogent evidence. If you have an award, something that lists your name, this can be very useful in terms of showing national interest waiver. Similarly with presentations at conferences. Patents, I would say approved are going to be much more valuable. Provisional, pending patents, probably a lot less useful. So if it's all possible, approved is going to help you more so on that front. And proof that companies are in fact using your research. Now, I mentioned here contract letters, and I talk about here reference letters from experts in the field. It is a critical part of these cases, proving up what it is you're doing, this side of things. You do want to get these good reference letters to bolster your claim, to support what you're doing, all of this. The idea here, though, is immigration does sometimes push back, because they can sometimes see reference letters that you have obtained submitting as being somewhat biased, because this person, you've asked them to write a letter, and they've agreed. All of this, it's somewhat it can have the element of being biased. So this is where, as much as possible, you do want independent experts. Generally prefer people who aren't, your direct supervisor, not a co-author. 4 to 5 letters, 4 to 5, not 45. 4 to 5 letters is probably going to be enough. You don't want to overdo it, and we'll talk about later. You really don't want the primary basis of your application to be reference letters, because if they start challenging that, you don't really have a leg to stand on at that point. So you do want to be corroborating all of this stuff. But letters wise, maybe 1 or 2 from a supervisor can be okay with regards to the first prong about what it is you're actually doing, but you don't want the letters really from those people to be talking about your abilities or contribution to the field, because of this bias that exists. So always good to kind of get an overview of a wide range of different people signing off on those letters. Research statement, always want to include that. USCIS does have training. They do kind of understand some of what we submit to them, but you want to make it easier for them to understand, so that they can understand in layman terms what it is you're doing and how that impacts the national interest. So research statement, very useful to include at this point. So the prospective nature, I mentioned this briefly before, national interest waivers have this perspective. So you do have to show that your future research must be in US national interest. So if it's focused on this prospective nature, why are we focusing so much on past achievements? At the end of the day, immigration typically understands that, your past record of achievement is going to indicate future benefits. I mean, it's hard to prove something in the future, that something's definitely going to happen, but if you have a past record of achievements, that stands you in good stead to be able to show that you will have this prospective future impact. And I mentioned this before in terms of self-sponsored. Do you require a job? What type of job? Self-employment, all of this kind of stuff. I mean, yeah, there's no need for an employer, no need for them to pay for your application, as there are on some of the other employment-sponsored green card applications. But yeah, I mean, it's still a good way if you have an employer lined up to be able to show that, you know, I will be able to continue to work in this field and move forward with that side of things. Completing PhD, postdoc, applying for the NIW, again, can still work as long as you can show that you are going to continue your research. This is where job offers can help. Changing fields, changing research fields can be a bit of a problem on some of these. It doesn't have to be in the exact same field. You can switch a little bit, but an example being, we see a lot of people going from science to technology transfer. That can be considered a major change. It's hard to justify based on your accomplishments, based on your achievements. So something just to keep in mind as a possible issue. A couple of key national interest waiver processing points. I mentioned Chinese and Indian nationals before. There are backlogs. Those particular ones update every month on the visa bulletin, but they are pretty backlogged because they come under EB2, which is EB's second preference. So it can take a while. The idea here is that you could file stage 1, you could file your national interest waiver, you could get it, you could file premium processing, you could get a decision in 45 days, but that only gives you a priority date, which is basically similar to when you go to a deli counter. You pull a ticket, you've now got your place in line, but the line for those born in China and India is pretty long. So you can hold on to that ticket, but it's going to be several years potentially before you're able to file second stage, the actual green card application. And this first part doesn't give you anything other than the potential to apply for a green card. It doesn't give you work authorization. So you need to be able to, during that period, be working on some kind of a work visa if you're here in the US still. So this is where things like an H-1B, O1 visas, these kind of things can be useful to allow you to remain here, continue working, because you're working based on that H or based on that O, not on this maybe approved national interest waiver. Pass over the slower premium processing because it's only 45 days. One thing we have seen with some Chinese and Indian born nationals is that you can, in certain situations, if I mentioned this place in line, if you file a national interest waiver and you establish a priority date, so you've got your ticket in line, even though it could be several years before you're able to actually move forward with the green card, there is something called EB1. There is EB1, extraordinary ability, currently still backlogged for Chinese and Indian nationals, but a lot less. It's maybe a year as opposed to 5 or 6. So what some people will do is they'll just go ahead, file a national interest waiver, so at least you have your place in line, and then work on building up an EB1, EB11, EB1A, extraordinary ability case. The idea being that if and when you get that, even if you can transfer your priority date from the old national interest waiver to this EB1, which means even if the EB1 is maybe backlogged by a year, you might be able to move immediately on it in 2 years' time because you already have that ticket, that priority date from the national interest waiver application. One word of warning I do want to raise here, a bit of a red flag, is filing an I-140 and applying for F1, even if you're on OPT or J1 visas subsequently. Due to the long wait, if you are filing an I-140, it can be tricky with an F1 renewal, if you need an F1 renewal, or if you need to apply for a J1. Both F1 and J1 have very strict non-immigrant intent, so you have to be intending to only stay temporarily, you're going to return home afterwards. If you filed an I-140 and immigrant visa petition, it could be an issue, could be something to consider, particularly for those. Again, we're going back to the Chinese and Indian nationals, just because in those situations, you file the NIW, you're going to be waiting a while before you can file stage 2. For everyone else, it might be a situation where you've got stage 1 approved, you just move forward with stage 2, and you don't necessarily worry about the renewing an F1 or applying for a J1, but definitely something to keep in mind. So, aliens of extraordinary ability. This is the one where you really are looking at showing that you're top of your field. It's a much tougher standard than national interest waiver, but it's looking at different things. Now, the process for EB11 or EB1A is either you have a one-time achievement, you have a Nobel Prize, you have an Oscar, whatever it is, photocopy that, send it in, great, you've got your EB1, you're good to go. Now, for everyone who doesn't have a one-time major international award, you're looking at meeting 3 out of 10 criteria, evidencing that you have risen to the very top of your field. So this is the majority of cases that we see. We'll get onto those criteria in just a second, but first thing I do want to mention is it's very important to define your field at the very outset of your case. This is a self-petition. You can technically have an employer sponsored, but it's not necessary. But when I say define your field, the idea here is the narrower you make the field, the easier it is to push yourself to the top of it. So it's very important to figure out what that is, what that looks like, how we're going to narrow that field, how we're going to show that you're at the top of that particular field. And just one of those things where it can really help. You also, the one issue would be is you don't want to make it too narrow that a lot of your previous accomplishments fall outside of that field, because then immigration could come back and say, well, yes, you have press about you doing this, but this isn't relevant to the field that you're applying under. And again, this gets into what we talked about before. This is complicated. It's not a one-size-fits-all situation. You do want to discuss this with someone, but this is kind of part of what you're looking at. If you've already been granted an O1, you might qualify for an EB1 easier. The EB1 is a higher standard than the O1, so plenty of people get an O1 and get denied for EB1. But particularly in the sciences, it is very similar criteria. So if you've qualified under an O1, you're going to be using a lot of the same evidence, maybe more. Hopefully, you've bolstered the evidence since then to apply for the EB1. The first step, EB1 criteria. This one, we're looking at lesser nationally or internationally recognized prized. So I mentioned the one-time Nobel Prize, great, you're in. But this is one of the criteria here is if it's a lesser national award, like something else that would work. Typically, this wouldn't work with grants. Grants aren't considered by immigration as an award or a prize there for prospective work, so typically not something you can use. And they're also very kind of against student awards. So it has to be, it doesn't have to be like a one-time Nobel Prize, but you're looking to make sure this is a pretty distinguished award in of itself. Membership in association that requires outstanding achievements as judged by recognized experts in the field. Typically for this criteria, membership dues are not going to be enough. If it's an association, pretty much anyone can be a member as long as they pay the fee. That's typically a big no-no. Immigration wants to see that it's tough to become a member of this organization. And they really want to get into detail about showing, what are the selection criteria, who's judged by, all of this kind of thing. The other part here is published material, similar to national interest waiver, but if you have this, we're looking at, things about you and your work in professional major trade publications. In this regard, you want to make sure that this published material is ideally lists you and talks about you as opposed to just the project, because the more distance there is between you and the press, the more likely immigration is to say, well, how is this about you? So ideally interviews, this kind of thing. And, this is something, again, that you can build up. If you ever have the opportunity to do this, to be interviewed by someone, go for it, because it can be useful for this. Participation as a judge of the work of others in the same or an allied field. This is actually one that immigration is a little bit more lenient on. You know, I think it's a good criteria to be able to get. If you ever get the opportunity to judge, you have to actually participate, not just be invited. But if you're judging the work of others, this can be something else that you can use. Original scientific contribution of major significance, similar in a way to what we were talking about earlier with the national interest waiver. Obviously, there's a few major parts here. You have to show it's original, and you have to show its major significance to the field. Can't just be to your employer. So this is a case you want to get as specific as possible with this one. Immigration sees everyone, you know, actors saying they're making original contribution of major significance. You need to have something specific that you can point towards. Authorship of scholarly articles in the field. You know, this is definitely a big one. You know, the more scholarly, the better. Citations, I mentioned citations of around 50 being good for a national interest waiver. For an EB1, probably looking at 1,000 citations or more being what you'd need to see. So it is a much higher standard, but, you know, scholarly articles can definitely work. Display of your work at artistic exhibitions or showcases. This is a bit of a tough one. If you're a scientist or researcher, I tend to just say kind of let's ignore this one. Immigration is very restrictive. They pretty much only allow this one for people who are in the arts. Similar to this last one, evidence of commercial success in the performing arts. Unless you're in the performing arts, they typically ignore those. There are some abilities to do some other things on that, but be able to show that it's comparable, but that's the main issue there. Lead or critical role for organizations or establishments with distinguished reputation. This one can be a useful one. You know, if you can show that your position is a lead or critical role, which is often shown by reference letters from individuals within that organization, to be able to demonstrate, or letters, or even organizational charts. Sometimes they want to see, just to show that you really do have a lead or critical role in that company, and that the company is one that has a distinguished reputation. So this can be another good option. So comparable evidence. One of the good things with the EB1 is they technically say that if one of the criteria doesn't readily apply to your occupation, comparable evidence may be submitted to establish eligibility. So obviously, me as an attorney, I love this because this basically feels like carte blanche. Like, yes, we can basically make up our own criteria and qualify people. But immigration kind of pushes back a little bit on that. You know, I mentioned here evidence of success in performing arts. Clearly, that doesn't apply to a lot of occupations, doesn't apply to the sciences. So we can often argue comparable evidence there. You know, similar, you know, scientists can't argue work in artistic showcases, but maybe comparable recognition for achievements would be presentation at national or international conferences. Maybe invited oral presentations are more persuasive evidence than poster presentations. Like, a lot of this other stuff can be used, and you can kind of put it in as comparable evidence. But immigration gets a little bit finicky on this sometimes. They will push back because they like to have checkboxes. They like to be like, well, here are the criteria that you have to meet. And when we start creating new criteria, yeah, they just get a little bit irate sometimes. Not to say you don't want to do it, you don't want to try it, and you often can in these kind of situations, but you don't necessarily want to be relying on comparable evidence. You kind of want to ideally be hitting as many of these other criteria as possible, and maybe have comparable evidence as, you know, a fourth or fifth criteria. You only need to hit 3, but obviously you want to try and hit as many as you can. And one of the main reasons for that is the second step. Now, this is kind of frustrating. We could do a whole presentation on why this shouldn't be the case. This shouldn't be the law. The idea is if you meet 3 criteria, you're in. But we deal with the facts of the situation as we find it. So the idea here is that even if you satisfy 3 or more of the criteria, immigration can still deny you at this stage. The idea being that immigration looks at it, they say, great, you've met 3 criteria. Now we're going to have a look at your case on the whole and make a decision as to whether we think you're strong enough. And sometimes they can deny on this point. So I use the example here, if you have reviewed 1 manuscript, authored 1 article, received 1 lesser known award, that might satisfy the minimum number of criteria, but they can push back and say, well, overall, we don't think you meet this second step, the final merit step. So something else just to keep in mind on that front. So this is where, if you can hit as many criteria as possible, 4 or 5 would be great. Is going to help you in the long run to be able to hopefully get past this final merit stage. Issues specific to researchers in this area, obviously talked about most of these before, but publications, you're looking at quality of the journals, impact factor, reviewing, again, the quality of the impact factor. Are they in your name or in the PI? What are your contributions? What citations do you have? The number of articles and the periods of which they were published, because with this one, you have to be able to show that your claim has been sustained. So if you have a bunch over the last 3 months, you could get pushed back on, is this really sustained? Or is this, just kind of a flash in a pan kind of situation? Mentioned student awards are generally discounted and grants typically seen more towards future. Critical leading role, yeah, we've kind of covered most of this actually in terms of supporting the position, showing that your project is critical to the organization as a whole. But what I did want to mention on this front is immigration has been pushing back recently on showing that your contributions, your lead or critical role is critical leading to the organization as a whole, not just a simple project or not just for a certain department. It needs to be to the organization as a whole. And if it's a big organization, this can be hard to show. But again, it's doable in most situations. If you can show that you're critical to this department, then you can show the department's critical to the organization. You can kind of make an argument. But yeah, the last one we did want to put here is choosing your referees carefully. Similar to national interest waiver, you do want reference letters to help support some of this stuff. But the more acclaimed they are, sometimes that can make you look less extraordinary. Immigration can sometimes come back and be like, wow, the person who wrote this reference letter, it looks like they would qualify, but in comparison, it doesn't look as though you would. So just something else to keep in mind. Requests for evidence, these are very, very common with EB1s. You have to read them carefully because often immigration is making mistakes, not really following the law. So you do want to make sure that if that's the case, you point that out to them. A primary complaint that we see all the time is about reference letters. Maybe there's too many reference letters and they don't really think that they don't like it because it's not corroborated by other stuff. So again, we talked about this before, but reference letters can help a case, but they can't be the sole basis for the case. So we're going to move on to green card lottery. We're not going to go over this in too much detail, but suffice to say, it exists. There's a website. It's 50,000 green cards. About 10 million people apply. Registration period is October, early November. You must be eligible to participate. Not everyone is. It's based on country of birth. Countries that have previously not been eligible are listed there. But if you are from a country where, the idea here is if it's a country that there isn't a large number of immigrants from that country to the US, then they can be eligible for this green card lottery. So it's definitely an option. If you're eligible, you might as well put yourself in there. If your spouse is from a country that would be eligible, you can cross-charge to them. So these are things that can be looked at. family-based green cards. So yeah, family-based immigrant visas. These are mainly immigrant immediate relative. So if you marry a US citizen, they can sponsor you. You can sponsor a parent if you're a US citizen, so you can be sponsored at that point. Minor children of US citizens. So these are the main categories for family-based immigration. I would say, a lot of times people say, well, I have a kid here and they can sponsor you. Yeah, but the kid can't sponsor you until they turn 21. So even that's a long wait, maybe longer than some of the other backlogs that you would see. But there are situations where you're able to do this, immediate relative, spouse, parent, minor child. They can file a green card for you. You can get work permit within 4 or 5 months, 6 to 8 months for the green card processing. If you get married and it's a very short marriage, you often only be given a 2-year conditional green card. At the end of that 2 years, you have to file another petition to remove the conditions. But these are obviously another option to go down the green card route. But similar to the employment-based situation, there are backlogs. I won't go into these in a huge amount of detail, but brothers and sisters of US citizen, it's 14+ year wait. It can take a really long time. I would say, I think this has actually changed here. The spouse of the legal permanent resident is right now pretty current, so that can be a pretty quick one. Very similar in time frame to marrying a US citizen. But as you can see here, brothers and sisters, 14+ years. There is no category for nephew, uncle, anything like that. We often get that question, but brothers and sisters pretty much the furthest you can go, and even that, it's so backlogged that it's going to just take way too long. And then did want to touch base on the adjustment of status. I mentioned this is the second step once you've been approved for the first, the immigrant visa petition. This is actual immigration. This is where they're checking for your identity, your criminal records, immigration violations, doing medicals, all of this kind of stuff. For that national interest waiver, they're not really looking at that. They're just solely focused on, do you qualify for a national interest waiver? Do you qualify for an EB-1? This is the part where they're looking at you specifically, trying to make sure that you're eligible for a green card, all of this kind of stuff. Kind of brush over this. I mean, birth certificates, Indian birth certificates, depending on where you're from, it can sometimes be to get. It's one of these situations where you do want to make sure that you have a long form birth certificate. When you're filing the second stage, it can sometimes take a while to get hold of that, so it's good to get on with that. Criminal records, if you have a DUI, if you have anything like that, you want to make sure you've got a full certified court disposition. DUI typically doesn't lead to too many issues with admissibility as far as immigration is concerned. It can do as far as more of the medical side of things, if they think you have a problem with alcohol, drugs, or something like that. But something else just to bear in mind. Mentioned this before, but you do probably need to maintain your underlying immigration status. The immigrant visa doesn't get you anything, so you do need to make sure you have a work visa, something like that moving forward to allow you to stay here, to allow you to work. If you file the green cards and you're in good status, you most likely can remain here, but it does depend on, what happens with that green card application and all this kind of stuff. Dependents, spouse, and children under 21 are eligible for green cards as well. So if you get approved for the national interest waiver, spouse and kids can also get a green card on the basis of that. There is work permit and travel documents within 120 days. It sometimes takes longer than that. For a while there, we saw them taking about 8-9 months. Right now, probably more like, I've seen a few come through in about 2 or 3 months, which is always good. I don't know how long that's going to last, but hopefully, long may it continue. But the idea there is once you file that second stage of the green card, you may be unable to travel abroad for periods until you get that travel document. So always good to keep that in mind before filing that second stage. Interviews, they've kind of moved away from this, but particularly if you have any criminal issues or if you have an issue getting fingerprints, if they're a bit too faint, they will often call for an interview just to go through the application, ask you questions, verify things. It doesn't tend to be too much of a problem. Consular processing. So, this is an alternative to adjustment of status here in the US. This is where you go through the process abroad. You do the medical abroad, you eventually have an immigrant visa appointment abroad. You go there, you pick up your immigrant visa, you then travel to the US, and upon entry to the US, your green card is ordered for you. This can be useful if you just run out of time here. If you've gone through a bunch of different visas, there's no other options, you have to leave, you're going to work from home, or you're just going to relocate abroad for a period, you can still go through the green card process via consular processing, be outside the country, work from there, live there. But then once the immigrant visa comes through, travel to the US and start working out here. So yeah, just something else to bear in mind. And very briefly, J1 subjects. So if you have a J1, it's typically on the DS 2019, it may say that you're subject to the home residency requirement. If you are, this basically means you can't apply for the green card until you've been home for at least 2 years or you receive a waiver. So obviously this can impact other things. And again, going back to our disclaimer earlier, like it's gonna be very different for everyone, but something just to bear in mind if you're on a J, check whether it's subject and see about waiver options. There are a few, typically no objection, claim for persecution, exceptional hardship, this side of things. Like these are options that you can do to get a J1 waiver. It can very much depend. Fulbright funding, for example, typically very hard to get a waiver on that. You may be forced to go home for 2 years before you'd be eligible for that second stage of the green card. And with that, I wanted to open up to the questions. Here's just my email address again and some information about some of our offices around the place. But yes, I will bring up some of the questions now. Okay, so we have a question. Can a sibling sponsor a family-based visa? If yes, is there a difference in processing time? Yes, sibling can sponsor, but it's kind of a long wait. And the problem is, I mentioned, there's a first and second stage of the green card. They can follow stage one, the I-130, but because there's a 15-year wait, it's gonna take 4 or 5 years for them to even adjudicate that one. And while that's pending, even once that's approved, that's not giving you the ability to stay here. So it's tough. It can be a tough one on that front, but it's going to take a long time. It's something that we do see some people do. If they've got a sibling US citizen, they file the case, they just get it started. So at least down the line, they have the ability to move here eventually if nothing else happens in the interim. But it's one of those categories that certain administrations have talked about maybe getting rid of at some point. So we just don't know if it's gonna stay in there. Another question, can someone with a master's degree demonstrate qualifications for O1 visa or EB1 too? Honestly, I mean, you need the master's potentially for EB2 for the national interest waiver, but for O1, EB1, they're not really too bothered about your education. Their focus is on your accomplishments. Do you meet those criteria? If you do, great, you're in. If you don't, you're not. So those two, masters is all well and good, but it's not going to really help too much on that front. We have a question, attorney fees, which it would be different for everyone, so feel free to reach out. We can talk about that. Average number of people who obtain green cards through EB2 on a yearly basis very much depends. I would refer you to our Chatting with Charlie YouTube series, just because that goes into, particularly the most recent one with chart 5, goes into a lot of detail about what they're currently seeing on EB2, how many applications. It's kind of a strange one because with COVID because it's impacted the local embassies and how, whether they've been open, whether they've been able to process visas. There was a decline in visa applications at that point, or visas being issued. So they've moved some of the spare visas over into other categories. That will likely change as we move forwards. But again, good to check on that and good to be familiar with the visa bulletin, particularly if you're a Chinese or Indian national, because it is something you do want to keep an eye on. If we file for national interest waiver and it's approved, we still have to renew your H-1B. Yes, you would, because unless you can file for the adjustment of status, which will eventually get you a green card and get you the ability to be here, to work, this kind of stuff, you need something in the meantime that you can work on. So if it's H-1B, by the way, is a dual intent visa. So maybe this is the meaning behind your question is really dual intent means that you can both have an H-1B working visa and be here temporarily, because you're on a work visa, but you're allowed to also be applying for a green card. So it's one of the great things about the H-1B. Do I need a lawyer to sign my petition? Nope, you don't. A copy of the presentation. Yes, that should be fine. While we're waiting for an interview, are we allowed to work or stay in the United States? Depends where you're at. If you file the adjustment of status and it's pending and you've got your employment authorization card, you can obviously work using that while you're waiting for a green card interview potentially down the line. But otherwise it might be a situation, you just have to make sure. And again, it's good to speak to someone to get a sense as to your specific situation. But ideally, you need to have something that allows you to be here, be it a work visa, employment authorization card, or something like that. We have a question on the H-1B lottery OPT process. Yes, happy to answer questions on that later. I think it's probably a little bit too much to go into right now, but feel free to reach out on that. Would an organization like NATO sponsoring my green card quicker for my internship or full-time, or does that come under a different category? I mean, there are G visas and other visas that are available that might work on that side of things. Typically with national interest waiver, I mean, it can be beneficial if you're able to get a letter from someone within that organization that talks about the national impact of your work or something like that. But typically, I don't really think there's much else there that would kind of speed things along, at least from an immigrant visa standpoint. And I think, if I'm seeing this right, I think that's all the questions I'm seeing here. Adi, unless you had anything else?
Oh, you covered them all and very rapidly, so great work. So we do have, so one other question, the best way to reach you.
Email. Best way to reach me, generally speaking, email. So.
Let me type it in for you.
Oh, sure.
Was it?
Either one works. It's either richard@wolfstuff.com or rem@wolfstuff.com. I think I just stopped the presentation.
So rem@wolfstuff.com. All right. Well, nice job being very efficient with that presentation. I found it really informative personally. I hope you all found it helpful. This workshop is being recorded, so once I've had a chance to, edit the beginning a little bit, I'll upload it into the Career Center's YouTube channel, so that will be available for all of you to view again. Rich, if you're okay with me sharing the presentation, I can do that in like a PDF form, so I can send that out to you all after this as well. I have your emails from the registration, so. Yeah,
absolutely. It's fine with me. And yeah, thank you so much for allowing us to do this presentation. It's always enjoyable to kind of do these things and go through these. And I love the questions that we got as well. I think, do we have one more?
no, she was saying thank you.
Okay, cool.
Yeah, it was our pleasure to have you, and looking forward to working with you more in the future. And I really appreciate your time today.
Perfect. Sounds good. Thanks so much.